suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Yes, it is that time of the week when David Whiting, Melbourne solicitor, joins you and takes your calls. And there are lines free, 1300 222 774. Good morning.
Good morning.
Now, you had homework, which we'll get to in a minute, but there's also news. And I wanted to ask you about this letter that's been sent to a federal court chief justice yesterday. And it comes from, this is a rare case of the media binding itself together on the same page. It's Nine, News Corp, the ABC and the Guardian. They're upset by some new rules around access to court documents.
Okay, had a look at this morning, and I'm truly fascinated that we're leading with a change to the federal court rules.
What would you like to lead
Well, it
with?
just strikes me that I don't know anybody out there's actually read them unless you absolutely need to.
Well, I guess it's making headlines because of the suggestion that this is a full, well, I think that, as the letter said, a full frontal assault on the principles of open justice.
Is justice, it's an interesting question, is justice the issue of proceedings or is justice the determination of the issues in the proceeding? Now, what's happened is that the Federal Court Rule 2.32, and there are many, many federal court rules, talks about access to court documents. And there's a set of rules in relation to a party having access to, if you like, to everything. And then there's another set of rules that says that someone who isn't a party can have access to the following. And there's a whole list of what they've access to, and it's the originating motion, the statement of claim, which is where you say, this is what I want, this is why I want it. And there were rule changes made in December which came into effect on Friday. And what they say is that while it's the same degree of access, it doesn't start at the same time. So the degree of access, that the access that was in place started the moment the proceedings were issued. So a journalist would make a scan through the list of cases issued at the federal court today, and they would then go and get a copy of the proceeding and write a story about it. Now, what the court says is, well, we think that's too early. What we think is that the procedure now is that there is what's called a directions hearing where the court makes orders as to the further conduct of the proceeding, and there is now the rule which says you can have them then.
Do you think that's fairer from a procedural point of view?
Well, I've always been fascinated to read articles in the newspaper that start from, that look to me as if they were written by the plaintiff's lawyer, who has tipped off a journalist with the issue of a statement of claim. Now, I'm sure that happens incredibly rarely, but it happens a little bit more often than so it's in a sense, it's litigation by press release.
And with no right of reply or other side.
Well, no ability to reply, but I've issued the press release, I've informed the court, I've informed the public that I've issued a proceeding in court. Here's a copy. It's now been issued with qualified privilege, and I can report properly on that. I'm saying what this does is slow that process down just a little bit. So I would have thought that it would stop that process. I'm now terrified. No, my phone is off. Good.
So essentially, it's delaying it ever so slightly, but not necessarily, you would argue, amounting to an assault on open justice.
On the principles of justice, no, because I think the justice is the determination of the case, not the making of the allegation.
Homework?
Homework, we actually had two. The first one was Craig from Blackburn, and Craig's question was his brother they'd had a mess up in relation to Mum's estate, and his brother was saying he wants interest. Well, you can have interest if you're receiving a legacy, so a fixed amount of money under the terms of the will. The entitlement to interest arises 12 months from death, and the interest rate that is applied is kind of complicated. It's 2% higher than the Reserve Bank cash rate last published before the 1st of January in which the right to interest arises.
Right.
So now the last interest rate rise from the Federal from the Reserve Bank was in December, and it went to 3.1%. So if you're entitled to interest and your right to interest arose this year, it will be 5.1%. And when you consider that the 90-day term deposit rate is under 2%, it's an incentive to pay. Who pays the interest? It comes out of the estate, so
You have
the
to make an
residuary
application,
beneficiaries get
or-
less. No, you're entitled. Until this change came through in 2017, you needed to make an application to the court for interest, and the interest rate was, at that stage, was 8%. It's now a rate which is variable.
Okay.
And the last call was we had a gentleman, Neil from Footscray, who was very upset about, Footscray's City of Maribyrnong, worried about rubbish left after rubbish trucks come to visit.
Oh, yes, and bins being knocked over.
Yes, yeah. My view is it's an issue that rests with the person who emptied the bin. And if the council chooses to do nothing about it or not a lot about it, I don't see there's much you could do. Because if you like, the council's not going to charge the council with littering, but there might be a complaint in relation to contractors.
Yes, I was going to say maybe their service contractors could be told to do a better job.
Yep.
1300 222 774 is the number if you would like to talk to David Whiting. Glenn in Doncaster. Hi, Glenn.
Hello.
Glenn.
Good morning, David. I run a small little Facebook group of adventure riders, motorcycles, sort of on-road, off-road. And I ran a group ride on the weekend. We had about 12 riders, remote areas around Hilden, around 300 Ks. Do I have any legal liability by taking riders off-road with me when there's no payment involved?
You may. And it really will be, in my mind, part of it will be the way you extend the invitation. I would have thought that if you were extending an invitation to me to join one of your rides, there would be an expectation that it was safe, and that whether someone would sue you or not, I don't know. I can see that there would be a liability if the tasks that you were getting them to do were inherently dangerous, or if they had a problem. So yes, you may have.
Anything on two wheels is inherently dangerous. I've tried to.
You're not helping yourself, Glenn.
I'm not, am I? I've tried to describe the routes and really map everything out and make it clear and give people a sort of an idea of the skill level required. Just wanted to know if someone crashes, whether it's on a asphalt road or a dirt road.
Would it make any difference if Glenn asked people to sign a disclaimer, or...?
There are particular forms of disclosure you want if the task you're doing is inherently dangerous. So you could get the disclaimer, but you're kind of, it's between your rock and a hard place. The moment you start producing the disclaimer, you're now effectively setting yourself up as a formal organiser of the roads, which what I would have thought sort of says, yes, I'm squarely in the gun here. I'd also point out that I'm assuming all of these vehicles are registered. So,
yes.
And then everybody's going to be looking at the Transport Accident Commission first.
Good luck,
and
Glenn.
just the last little question, if I may. Are there any restrictions from Vic Roads on max numbers per ride?
I would not have thought so. They license drivers. They don't license group activities.
Glenn, enjoy safely. Mark in Bayswater. Hi, Mark. Mark.
Hello?
Yes, hello. Hello.
Yeah, I've got you. What my question is, I'm the executor of a will. There's a few motor vehicles in the estate. I want to know, I've got some people who want to buy those motor vehicles now for a good price. I want to know, probate hasn't started as of yet. I want to know, can I sell those motor vehicles before I commence probate and put the money in the estate bank account? Or do I have to wait till probate commences? Or do I have to wait till probate is finished before I can sell the motor vehicles and put the money in the estate's bank account?
I think the answer is yes, yes and no. Mark, you have the right to... You are the executor named in the will?
Yes.
Do you intend to make an application for grant of probate?
Yes.
Then there would be nothing to prevent you from selling the bikes now. The question...
motor vehicles, not bikes, motor vehicles.
Sorry, motor vehicles. Okay. The issue will be whether or not Vic Roads will probably process the applications. It really is, if I was to give you a great sum of money for a particularly nice motor vehicle, how do I know that you're the person who's got the capacity to do what you're doing? So it's protection for the buyer, not protection for you. There's also an issue if something should happen and you not get probate, then maybe someone else can come to the buyer and say, you haven't paid the right person, give me the money.
Right.
The protection is for both of you, Mark.
Right.
Unless you're absolutely desperate, I would wait for a grant of probate, but you could have a grant of probate within a month.
I thought you had to wait 6 months to get a grant probate.
No, you can. The process is you lodge an advertisement for an application for a grant, and you can't lodge the probate for 15 days. So that's the 15-day notice period. Then you can lodge, if you've got all the information about assets, you can then lodge your probate application. It normally takes, in my experience, between a month and 6 weeks to collect the information.
So, a question, David. That's an advertisement in a printed form?
Well, it used to be.
Yeah, right. So now it is slightly more modern.
They used to be in the Age or the Herald Sun, or probably the Sun or the Herald, back as it was. It's now on the Supreme Court website.
So it is online. They've come up with the times.
They have, and they've made it a lot cheaper.
And once you've lodged, how long until it's granted?
Between 5 and 7 working days, so not long.
Okay, so it's
at
not
all.
that long.
No,
Yeah.
no. And you now lodge electronically. So it's, I always consider that what we're really doing is doing data entry for the government. But yes, you lodge electronically.
Yes, indeed. Mike in Oak Park. Hi, Mike.
Hi there. How you doing?
Good.
Yeah, thanks, David. I was in Brisbane for a few days just before Christmas, and I took an Uber to the airport when I was leaving, and that was all fine, talking to the driver, and incidentally, just to come clean, I have actually been an Uber driver for a very short time. It didn't work out for me, but that's beside the point, I think. My wife and I took Uber to the airport, paid the fare, and no problem, and I got home, and the next day they slapped an $80 extra charge onto my credit card, claiming that we had left a mess in the back seat.
Okay.
And I can assure you we didn't.
Was there a mess in the back seat when you got into the vehicle?
No. So anyway, they sent me a notice about this, and stating that their team would do a report with photographs and stuff within 72 hours.
Yes.
And then I got another note saying might take a little bit longer because it's Christmas time, and so that's fine. I left it at that, and then after yesterday, which is obviously a few weeks down the track, I wrote back to them again and said, "Hey, what's going on? You said you're going to
you do X, Y, and Z." Yes. Yep.
Yeah, which they did not do. And then last night I got an email back from them saying, "Oh, this is an automatic generated, email because your case is now closed."
Then if you really, you have the right to complain back to Uber. You also have the right to go to the Queensland Civil and Administrative Tribunal, where you really want a declaration that you don't owe them the $80. I think I would keep going back to Uber about the issue, and if you really want to have a fight for $80, I'd say, or even dispute the transaction through your bank.
Yep. Okay. All right. Thank you very much.
Good luck, Mike. I mean, the case is not closed when they haven't even, bothered to give you a response. Jennifer in Fitzroy. Hi, Jennifer.
What I'd also say to Mike, though, is make the complaint immediately rather than wait for their process.
Don't wait.
Just come along and say, absolutely no way, I'm going to fight this to the nth degree, and then rather than here I am 6 weeks later.
Yeah, don't give them time.
Yes.
Yep. Sorry, Jennifer. Hello.
Hello, Jennifer.
Hi, I'm a property owner in Fitzroy, and I emailed you previously about a tenant complaining about pigeon excrement from a tree overhanging in the backyard.
Yep.
So that tenant has now moved out and subsequently retrospectively taking me to BCAT for the rent reduction that he didn't receive, that he feels like he needs some compensation for the lack of use of the backyard. Do you think what VCAT would say in that situation?
How long was this person a tenant, Jennifer?
12 months.
Oh, I would have said Buckley's.
Yeah.
I come along and I say, if I'm renting Jennifer's house in Fitzroy and I can see there's a tree with millions of pigeons in it, I ought to know that at the outset.
Yeah, and the other issue about it is the tree is actually overhanging and doesn't even belong to me, so, and considered significant under City of Yarra. So not even able, as a property owner, not even to...
To me, the problem is 12 months down the track, someone comes along and says, I've reconsidered my tenancy, I've paid too much rent because there was pigeon poo.
Correct.
Yeah, that would be, I'd be coming along and saying, make the complaint day one and maybe I'll let you go. But
Yep.
I'm not negotiating the rent.
Great. Thank you very much.
Thanks, Jennifer.
Thanks, Jennifer. David in Geelong West. Hi, David.
Good morning. David, we have a weatherboard bungalow in our backyard close to the neighbouring fence line. We recently found a tree on the next door property had grown across the boundary and was pushing in the wall of the bungalow, causing some significant structural damage.
Magistrates Court, David.
So I guess...
It's an action to restrain a continuing nuisance.
Tree.
Sorry?
So he's removed the tree,
Okay.
but he says he's not going to pay for the damages done.
You mean the cost of fixing the wall to your bungalow? Yes?
Which is about 15 grand.
Ouch. Still the Magistrates Court, David. It's damages for the encroachment for the tree.
But I guess the question is he legally responsible for the damage?
I'm going to say, David, how long have you been there?
I've been here 2 years, and he bought his property 3 years ago.
My problem, and you're in a perfect factual situation. I don't see that he's liable for the damage caused to your bungalow more than 3 years ago. No? So I can't imagine that all of the damage to your bungalow has been caused in the 3 years since he acquired the tree. And I don't, in all honesty, know the answer to that question. I've tried to play with it from time to time and haven't got there. So he's got his tree's leaning on your bungalow or that tree leant on your bungalow for maybe 15 years. I have no idea. And
So
you're
what
saying,
is he liable for 1/5 of if it's 15 years?
Yeah, well, technically no. He would be only liable for the last 3 years.
So that's 1/5 of the
damage.
total cost.
No, I understand that. But if you think about it...
All the
and you've
damage
got
was done earlier.
Imagine if you've got 2 car accidents and how much does the guy who hit you second pay? The answer would be, well, not really a lot because you could probably cover it all with the repairs from the first guy. So, David, is he liable? Yes. For all of it? Probably not. Can I take that as homework? It'll commit me to get an answer.
The other question is, if we had a building inspection done at the time we bought the property and it didn't show any damage, would that sort of indicate that maybe most of it's been done in the 3 years or 2 years since?
Yes, it would. That would be fantastic. But then, David, when we started this conversation, you said you'd found a tree in the back next door. And I'm thinking, you must have a very big backyard, David.
David, look, we'll take that. David,
take it for
David
homework.
Whiting will take that as homework and see. And building reports are not ever the be all and end all, are they?
Oh no, I had one.
Let's not go down that road. No,
yes, okay.
You've
one
had
where there
one?
was an extraordinary amount of termites that weren't picked up. Yep.
Yeah. Pietro in Caulfield North. Hello.
Good morning, everyone.
Fire away, Pietro.
Yep, go away.
Yes,
Go ahead.
look, I'm just questioning we've just received a couple of parking fines with a vehicle parked on private property, but with the bumper bar side of it overhanging the footpath, and we were fined as being parked on a footpath.
Yeah, you were.
So I'm just... Oh, you were?
You were.
So it doesn't matter how much of the car is on it?
Well, if what we're doing is here's someone who, you imagine you're walking down the street and there's a car sticking a foot out into the footpath. You're parked on the footpath. You've got to be entirely within your, I think the word is curtilage. You've got to be entirely within your property.
Oh, sorry, Pietro. That's the answer there.
It's almost like you're supposed to also park in the parking spaces on the road, although that often gets hard too.
Oh, yes, and especially I know entire roads where everyone seems to ignore them and they're half across the lines and it's just it's terribly confusing. And then someone tries to squeeze in between. Yeah, anyway.
Pietro, it's a valid ticket.
Sorry about that. Bernard in Dandenong. Hi, Bernard.
Good morning to you both.
Far away, Bernard. Yep.
I own an apartment in a group of 64 and it's for sale. And the OC in its wisdom has levied a guesstimate of potential maintenance on top of the core OC fee. At settlement, am I liable to pay that?
Language in my job, Bernard, is absolutely everything. If the levy has been properly formulated, even if, and so it's a capital levy, it's not a periodic levy, and it's been properly formulated, even if we don't know the exact price of the work, it's your problem. That would be adjusted against you at settlement.
Okay, so I am liable to pay the levy even though it's for potential maintenance where I won't be there.
No, sorry. It's not potential maintenance. That's why if you need to look very carefully at if it's a levy, if it's been properly constituted as a levy, even if we don't know precisely what we're going to do, then you're liable for it.
So it's for painting. So it's for painting, which will be 5 years down the track.
Then a levy to add to a reserve is a levy you have to pay. You need to have a look at the Owners Corporation Act and regulations and the wording used and work out whether it's a periodic levy, like your regular 3-monthly or 6-monthly bills, or if it's a one-off charge. If it's a one-off charge, you pay all of it. Yeah. If it's a periodic payment, special levy, then it's all yours.
Yeah, and it's all about building up the bigger the funds for the body corporate, isn't it? So if you're there at the time...
It is, but then I can see from Bernard's point of view, imagine you buy a house and the fence next door the fence is decrepit. What you're really acknowledging is that you're going to have to replace that fence at one stage. But if a fencing notice was served the day before you before you signed to buy, the compliance with the notice is your predecessor's problem, not yours. So Bernard's in the predecessor problem.
David, thank you.
Thank you.
David Whiting there. He'll be back next week with your homework done, won't you?
Yes, ma'am.
We do like someone like that. Very good. David Whiting there, Melbourne solicitor. He'll join you next Tuesday.